Yeah. Okay, I get it. It's all.
Mr. Goobin.
I don't need to hear it. I don't need to hear the blabby blab. Just stop talking to me.
I was just gonna ask, did you want to go in a breakout room?
What is a breakout room? I showed all my proof. I showed all the proof. I showed the proof, Mr. Sean Perkins. What is it? Is it my what is it? My
Have a good
complexion?
day, Mr. Have a good
It's
day,
my
Mr.
complexion, isn't it, buddy?
Have a good
Yeah.
day, Mr. Goodman.
Mr. Uneducated Judge.
Have a good day, Mr. Goodman. You keep on
How are
talking
you
out of
even a
turn.
judge,
I'm gonna
bro?
hold you. I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
What a clown.
You done?
Anything else?
Are you
Anything
done?
else, pal?
All right. I'm gonna hold him in contempt. I'm gonna give him 30 days Wayne County Jail. All right.
Clip. This is one of those moments where a case stops being about paperwork and becomes about ego. The judge isn't even ruling yet. He's trying to manage the room. But the defendant isn't listening. He's talking over the court, refusing procedure, and then crossing the line by accusing the judge of bias. Whether that accusation is sincere or just frustration boiling over, the courtroom is the worst place to explode like this. Judges don't hear disrespect, they hear defiance. And defiance has consequences.
Right, okay.
You have an absolute right to a hearing.
You will expect a huge lawsuit. I showed you every single proof of documentation that I needed to, and you refused to dismiss my stuff.
Have a great day.
Why is that?
Have a great day. We're not talking anymore, all right? We're done talking.
Yeah, that's what I thought.
30 days Wayne County Jail.
Once the word contempt is spoken, the dynamic completely changes. This isn't about tickets anymore. This is about control of the courtroom. Judges rely on authority to function, and when someone openly challenges that authority, punishment becomes almost automatic. 30 days isn't about revenge, it's a message. Sit down, follow rules, or the system will force compliance.
Yes, Judge, good morning.
And who are you here on?
I am here on Joshua Gubin.
All right, he has not showed. He needs, I told him to be here in person today, and he has not showed, not neither. Oh, I think he is here. He is here. Okay, so here's the deal. It's nothing really to talk about with Mr. Gubin. I told him to come in. I said I gave him 30-day Wayne County Jail for contempt last year. Yeah, I see him hold up a child. His child, he didn't come down. So again, he continues to defy orders of the court, and we just don't have much to talk about.
Well, Judge, I understand that that may be the court's position as it relates to this matter. May I have just 1 second? I apologize, Judge. I needed to plug my computer in. So I understand that may be the court's position. I just got retained on this matter this morning. I was not present at the hearing where you apparently held him in contempt. He obviously has an opportunity to prepare and present a defense to the allegation. I'm not sure if the court made a finding as to whether or not this was civil or criminal contempt, and further, whether the court actually determined whether it was direct or indirect contempt. Obviously, the court's ability to sanction an individual, especially with a deferred sanction, may be limited under these circumstances. So what I'd be asking the court to consider doing is giving me a brief adjournment so that I may obtain a copy of the transcript of the last hearing. And I would just cite to case law, which indicates that my client does have the ability to obtain an accurate transcript of the hearing as a matter of due process. And when we come back, I will be prepared to effectively, properly address this matter.
Well, the contempt was, the contempt was.
This is where the case gets interesting. The lawyer doesn't defend the outburst, he defends the process. He's asking real legal questions. Was this criminal contempt? Did the defendant get proper notice? Was due process followed? This is the calm after the storm. And it highlights something important. Even people who behave badly still have rights under the law.
Right on the record, on the record, and I do have, you can get the record for that. It was, I did hold him in criminal contempt. That's why I told him 30 days Wayne County Jail. And from my understanding of the court rules, he had his opportunity to contest that. That ship has long sailed, from my understanding of the court rules, because this was done over a year ago. And the only reason that Mr. Gubin come back before me is because he got some other cases. He let the tickets go on the warrant status. He only is before me because he got the other cases. So I still need his presence here. I'm going to readjust his bond now.
Well, Your Honor.
So he continued. I've let you speak, Counselor, and I'll let you do what you need to do as far as your job, but I'm going to do my job. And Mr. Gubin continues to defy the court's orders, and we'll talk about bond right now.
The judge makes it clear this wasn't impulsive. From his perspective, this defendant has a history of ignoring orders, missing court, and disrespecting the system. Judges remember behavior. Once someone earns a reputation for defiance, every future decision is filtered through that lens. Fair or not, past conduct matters, especially in bond and contempt cases.
I'll let you go ahead with bond.
Thank you. Your Honor, it is my understanding that mere traffic matters are pending before the court, at least one civil infraction, and I believe a no insurance misdemeanor. These incidents date back to 2022 based on my review of the Register of Actions. He has appeared in connection with this matter, which the court has noted. Apparently, he was here last week, and you may have recognized him. But the point of the matter is, I've known Mr. Gubin for a while. He always appears as required and as instructed. I understand that the court may have a difference of opinion as it relates to that, but I would attest to that. He is a lifelong Michigan resident. He has extremely strong family support. He is a father. He has minor children, actually, one of which is visible on the Zoom as we currently sit here. He owns his own business in Wayne County and operates that business very successfully. I think when you consider factors that are relevant to a bond inquiry and are not relevant to collateral matters such as prior actions engaged in allegedly before the court, personal bond is warranted, and it's my understanding that that is what may have been previously entered in connection with this case. Upon conviction of the only misdemeanor with which he presently stands charged, his maximum sentencing exposure is minimal. He is obviously presumed innocent at this point in time. And for all of those reasons, Judge, in addition to other reasons, such as his lack of any significant or substantial criminal history, which is a factor that the court shall consider when it sets bond, I believe a personal is warranted. And retaliation for what allegedly occurred in the past should not impact bond under any circumstance.
All right, very well. Bond is going to be set at $2,500 cash. I still, the order of Mr. Gubin still showing up because despite what you've articulated on the record, Ms. Backfires, I we put the warrant out for Mr. Gubin's arrest a long time ago. He was supposed to be in person here today. He's not. He also has an assault and battery case that he has a warrant out for his arrest for as well. So he showed the court and demonstrated to the court that he has not only with this court, but with the other courts and other judges in this courthouse that he has a failure to appear or something. So bond is $2,500 cash, and it's still ordered that Mr. Gubin show up in person to the court for the conviction hearing, and we will address and you can appeal the matter to a higher authority if that's what your client chooses to do.
So, Your Honor, I have a comment as it relates to a cash bond. I'm asking that the court impose a cash or surety bond. My interpretation
The bond argument is strong on paper: family, business, minimal charges, presumption of innocence. But bond isn't just about guilt, it's about trust. And here, the judge doesn't trust him to show up. Multiple warrants, prior failures to appear, and courtroom behavior all collide. That's why the judge doesn't budge. The final message is simple: comply first, argue later.